Hello everyone, and welcome to this video tutorial on vicarious liability. Vicarious liability is where one person is held liable for the torts of another, even though that person didn't commit the act itself. So in this way, it's a form of strict liability. And you can see here the most common type of vicarious liability is when employers are held to be liable for the torts of their employees, as long as the employee committed that tort in the course of their employment. So to give you a practical example of this, I'm an employee of Cronton Sixth Form College. If I did something negligent while I was at work, let's say I'm running down the corridor with a boiling hot cup of tea, and I negligently throw it at a student as I'm running, and it scalds the student. In that situation, obviously I've been negligent and you could sue me, but I don't have much money. It would be better off if you can sue Cronton College because they have a lot more money than I do. So because I'm the employee of Cronton and I was doing my job at the time, i.e. being a teacher, okay, I was doing it in a negligent way, but I was doing my job at the time, they can be liable and you can sue them in vicarious liability. And in that way, you're likely to get more compensation. That does seem a bit harsh because it's strict liability. It's not really Cronton College's fault. And they might have told me, Lucy, don't run down the corridor with a cup of tea. And I've ignored them. But also, it's sort of fair, it's reasonable because the master has the deepest pockets, but also they've taken the risk in employing me. And hopefully they should be employing sensible people who they can trust to act in a non-negligent way. In order to find an employer vicariously liable for the torts of their employees, we have to prove three requirements. Firstly, that a person has committed a tort, and it's usually negligence. So as I said before, if I'm running down the corridor with tea, that would be a negligent thing to do. The person committing the tort was an employee, and I am an employee in the example I gave to you a minute ago. And thirdly, the employee was acting in the course of their employment. I was at work, I was doing my job at the time. So they're the three requirements for vicarious liability. As usual, we're going to look at each of these in turn. Firstly, then, we have to prove that a person has committed a tort, and usually it's going to be negligence. So as I've said, I keep using the same example. If I'm running down the corridor with a hot cup of tea, that is a negligent thing to do. So that's the first requirement. And if you got this in a scenario in the exam, you would have to explain negligence first. So you would ID a negligence. Lucy might be liable in negligence for running down the corridor with tea. Define it, explain it, apply it. And then you go on to requirement 2 and say that Lucy was negligent while she was doing her job. It might be vicarious liability. We'll have to determine whether she's an employee. So the second requirement here is that you have to show that the person has employee status. And you would think maybe that that's quite obvious, but actually it can be very difficult to distinguish whether someone's an independent contractor or whether they're an employee. And employers are liable for the acts of employees, but not for independent contractors. In case you're not familiar with the difference between employees and independent contractors, I've summarised on this slide for you key differences. So employees must obey instructions concerning when or how to perform the job. They have an ongoing relationship with the company sets the hours, etc. So as a teacher, I'm an employee. The college might take on somebody to build a new building, build the playhouse, for instance, so they might employ independent contractors. And the independent contractors or the builders would be responsible for the outcome of the job, building the playhouse for the college. But that's not their only job. They don't work for the college. They advertise and make their services available to the general public as well. They'll set their own hours. They might work for more than one company at the same time. So they might be doing a job at Cronton and a job at a dentist's down the road, for instance. They have a lot more flexibility on how and when they complete tasks, and they'll provide their own tools and materials as well, whereas an employee doesn't. So on a very basic level, just so you've got an awareness, that's the key distinction between them. But it is much more complicated in real life, and we had a very recent case, Aslam, Uber and Farah, which illustrated that even in 2018-19, we were still struggling with this distinction between the two. So the courts have actually developed a number of tests for working out whether someone's an employee or whether they're an independent contractor. So we're going to have a look at each of these tests: the control, organisation, the multiple test. And in recent years, the courts have added another, and I'll add it on here. It's called the sufficiently close test. And we'll have a look at that as well. So the oldest test for determining whether someone's an employee or not was the control test, and you can see it comes from a case from 1880, Ewins and Noakes. And in this case, they said that a person's an employee if the employer had control over the work and could lay down how it should be done. So I like to imagine you're an employee if, it's not a nice way of looking at it, but you're a puppet. You're a puppet for your employer. They tell you what to do and you do it. In Walker and Crystal Palace, they said that a person's going to be an independent contractor and not an employee if they've got discretion as to how and when to do the job. I'm a teacher. I don't have discretion as to when to teach. I'm told, this is your timetable at this time. I go and do it. So I'm under the control of my employer. The second test that a court might use is the organisation test. It's sometimes called the integration test. And this is looking at how closely the work is involved with the core business. And in this case here, with lots of names, Stevenson, Jordan, Harrison, McDonald and Evans, you are welcome. The more the worker is integrated into the organisation, the more likely they're an employee. So that means you might look at things like, have they got a uniform? Have they been given their own desk? Have they got their own office? Are they clearly a part of that organisation and a permanent part of that organisation? In the textbooks, it's called the modern test, the multiple test, but actually we've had a more modern one even than this. But in ready-mix concrete, the court gave 3 conditions for being an employee, and these are quite useful and easy to apply. So firstly, your employee agrees to provide a skill in return for a wage. The employer has a degree of control, and nothing in the contract is inconsistent with employment. They can't delegate the work to someone else, for instance. Now, this is really the most modern test, the sufficiently close test. And you can see this is pretty recent, Cox and the Ministry of Justice. This was a Supreme Court decision, so it's very important. And they said that a prison service was vicariously liable for an injury caused to a supervisor when a prisoner who was working in the prison kitchen stabbed them. And they said that the relationship was sufficiently close to an employment relationship. Now, this is a strange one because obviously the prison service doesn't really employ prisoners, not in a traditional employment relationship. Sometimes prisoners will do work for the prison, but it's not a traditional relationship. But nonetheless, the court decided it was sufficiently close. So they were happy to find an employer liable there. We then had Uber, Aslam and Farah, which I mentioned earlier from 2018. And this case is useful because it just shows how complex it can be deciding whether a person's an employee or an independent contractor. And this was 2018, so this issue is still an issue for our courts. And a case from 2019 after Uber, this case applied the sufficiently close test from Cox and the Ministry of Justice. So although they said that the person was technically a subcontractor and not really an employee, they were still happy to find the employer vicariously liable because they thought it was sufficiently close to an employment relationship. So this is showing perhaps that the courts are very willing nowadays to find that someone's an employee so that we can hold somebody else, potentially with more money, vicariously liable for their torts. So that's the first requirement, that you have to show that the person was an employee. The second part is that you have to show that they were acting in the course of their employment. So Century Insurance is a good case to look at here to start with. So an employee here was delivering petrol to petrol stations, and he was actually smoking while he was delivering this petrol, and he caused an explosion. Now, his employers were being sued for vicarious liability, and you can see what they're going to say. Why is he smoking? That's not our fault. He's not really doing his job. He's not in the course of his employment. But the court said an employer will be vicariously liable where the employee is doing his job in a negligent way. So yes, he shouldn't have been smoking, but he was doing his job, delivering the petrol, at the time. So therefore, he was acting in the course of his employment. Similarly, in Rose and Plenty, a milkman was told not to allow children to ride on the milk float. But he ignored that, and children were riding on it and a child was hurt. And again, the employer is trying to say, well, he wasn't acting in the course of his employment because we told him not to do that. But the court said that he was still liable because the milkman was still doing his job, even though he was doing it in a negligent way. You do have to look out for, though, are they doing their job at the time, or have they gone off on a frolic of their own? And I love this phrase. It comes from the 1869 case of Story and Ashton. And here some employees were delivering some wine in a horse and cart, because it was an old case. And on the way back, they decided to go and do some business of their own before they went back to their employer. And at this time, they ran over the claimant. And here it said that the defendant was not liable because the employee was on, quote, a frolic of his own. So if the employee has gone off to do their own job, their own task, they're on a lunch break, they've gone off somewhere else, they're not in the course of their employment at that time, they're on a frolic. We always compare the case of Limpus and Iqbal on doing authorised work in a forbidden manner. So in Limpus, he was acting in the course of employment, even though he was told not to race other buses. And that's a bit like Rose and Plenty. So he was still doing his job, but in a negligent way. Whereas in Iqbal, the employer was not liable here because they told him, do not drive the bus. Basically, he was suspended and he drove it anyway. And then they weren't liable then because he wasn't acting in the course of his employment. He shouldn't have been driving the buses at all. Sometimes torts might occur when a person's travelling to work, so the courts have had to consider this, and they've decided in Smith and Stages that travelling to work is not the course of employment. So if I do a negligent crash on the way to work, my employers are not at fault. If, however, I'm travelling between workplaces, between Cronton and Riverside at the instruction of my employer, that is in the course of my employment. So midwives, nurses, going on visits to patients' houses, that will all be covered, but going home, travelling to work is not covered. If they go off to do their shopping, they decide, I'll stop at the laundrette on my way, I'll go and get a sandwich, that would be a frolic. And again, the employer would not be liable there using Story and Ashton. So the employer's only liable if they're going between workplaces and they're not taking a detour for their own personal reasons. The last element to consider for vicarious liability is what if the person does an unlawful act or a crime? And Lister and also the Catholic Child Welfare Society both show that an employer can be vicariously liable, got my tongue tied there, can be liable where a crime is committed. So in Lister, it was sexual abuse, and similarly, it was sexual abuse in Catholic child. And this seems a bit strange because you would say it's not the course of employment